And the man himself is in the studio with me. Hi Ashok. We shall deep dive into this discussion, and also joining us is Amod K. Kanth, former IPS officer and founder of Prayas NGO. Mr. Kanth, thank you so much for joining us on this debate. Considering that you have been doing a lot of, work which is reformist, your first, because there's been an outrage, as you must know, across, social media platforms, newspapers, magazines about what is this reformist bail? Because if you look at the teen's background, son of a super rich, successful realtor. His grandfather has also said, someone who's very influential, said that, the boy will reform, etc., etc. I mean, the car that he was driving is around 2.5 crores. He goes and spends 48,000 at a pub. But to say write an essay, spend time at the RTO, etc., etc., do you think this is just an eyewash? Do you think this should be treated differently, Mr. Amod Kanth?
I think the situation is outrageous, no doubt. And the way this child was allowed to drive, and very appropriately, the father of the child has been taken to task. I entirely go with that. But there are some confusions here. I think I have been hearing the views being expressed. Let me inform you that that child, that is juvenile of Nirbhaya case, was tried. That was legal proceeding was carried out within the premises of Prayas, the organization which I have been running for 36 years now, in Firozshah Kotla home, Juvenile Justice Board. I would not like to comment on about his culpability, which was also very different than what it was projected in the media. But that led to change in the law, 2015, in which I appeared in the Supreme Court of India, I appeared before the Parliamentary Standing Committee, opposing the change in law. That was my stand then. But now, having seen it, I find that perhaps appropriately 16 to 18 years of age. Now, let us clarify three legal points, because that people must understand. See, number one that the possibility of a child committing crime between 16 to 18 years should be a heinous crime, and heinous crime is described as a crime which carries punishment more than 7 years. Let it be very clear. Here is a situation. Here is a situation, for example, because there are 302 murder, 304 culpable homicide not amounting to murder, 304A causing death through rash negligent act. Normally, the case like this, inappropriately, that is wrong. The new CRPC, IPC is taking care of it. This particular case normally falls in the category of 304A, and 304A doesn't have punishment up to 7 years. So one has to see this part of it. So whether this case would be treated a heinous offense or not, I'm not saying whether it's right or wrong, but it was for Juvenile Justice Board to look into it. That is one. Secondly, there's something called preliminary inquiry. Because during preliminary inquiry, part of it was explained by my friend just now, he was speaking about it, that in the preliminary inquiry, whole lot of circumstances, whole lot of maturity conditions, whole lot of psychological and social issues are brought on record. And then the Juvenile Justice Board, if it comes to a conclusion that there is a possibility of treating the child an adult, not treating the child adult, but to go to the normal court where CRPC, IPC, etc. applies. If that is understood, then the child is taken to a children's court. Please understand. Right. The trial is conducted not by ordinary court, it is to be conducted by children's court or a sessions court, whatever of the same type. If they decide that the child should be treated like an adult, even then, let me clarify, the existing Juvenile Justice Act and other laws which go along with that does not kind of empower them to treat the child completely an adult. Let us say the child is kept during this period in something called place of safety. The home that Prayas ran for 26 years, and we had 21,000 juveniles who came in that home, is called observation home. The home where a child can be kept, this kind of child can be kept, happens to be a place of safety. So these are a lot of things which must be kept in mind before you come to a conclusion. Well, I think on the basis of it, the basic point is that it's a very serious thing. I hope you know that I handled this well-known BMW case, Sanjeev Nanda's case.
Yes.
In which, up to, let me inform you friends, that Sanjeev Nanda case, Sanjeev was not a minor. Sanjeev was an adult. He came from USA. He drove a similar kind of car in the dead of the night, and he killed 7 persons, 6 persons, including 3 policemen. And that was my case. It is in great detail written in my second book called Khaki and Broken Wings, published by Bloomsbury. I have written 50 pages on this. Now, this particular case, the three courts, starting from trial court, high court, Supreme Court, different views were taken. Somebody thought it was 304A, somebody thought it was 304. So this is a matter of
Okay.
judicial consideration, whether a particular case is causing death by rash negligent act or it is a homicide. And let me inform you, friends, that if it can happen in the case of that brutal case and serious case of BMW, it can be, other views can be taken.
All
in
right.
this case also, several views can be taken. So let us examine the whole thing in its legal perspective.
All
That is
right.
what I am trying to
Okay, so here I have two experts, Mr. Amod Kanth, of course, Super Cop, and you are the legal editor. First of all, do you have to, do you have any kind of a response to what Mr. Amod Kanth said? Because I think he was referring to you when you were doing the explainer for us, Ashok. Would you like to respond? And then I want to ask you a layman's question, which is, how do you define that even if I'm 17 years and 3 months old and I have committed a crime, that it happens to be heinous? What is that heinous definition?
Okay. So, first, I don't want to respond to what Mr. Kanth has said, but I just want to add to what he said. So, he spoke about the whole process as to how, this Juvenile Justice Act was amended and how this provision was inserted in the law, which said that a juvenile or a child in conflict with law, and if he is between 16 and 18 years of age, can he be tried as an adult? And the answer was yes, but there was a rider that considering that these conditions have been met.
Okay.
Now, here the question is, just because that we have a law in place which permits a juvenile to be treated as an adult, it does not mean that every juvenile falling between the age of 16 to 18 and has committed a heinous offense has to be treated as an adult. That is not the mandate of the law. The mandate of the law is the Juvenile Justice Act, which is as I said, is a beneficial piece of legislation. The objective of it is to care and protection of a child. Now, coming back to this case, the problem with this case is the facts of the case have been obfuscated by peripheral issues. Issues like, oh, a rich boy driving a Porsche, father is a real estate magnate, grandfather again a very rich person. This could have happened to anybody. Now, it's a very unfortunate incident because two precious lives have been snuffed out.
Yes.
Two young IT professionals have died. This act cannot be condoned. But please try to understand, here we have a juvenile who is involved. We heard Devendra Fadnavis say he is 17 years 8 months. So, the law says anybody who is less than 18 years is a juvenile. So, what do you mean by 17 years 8 months? Does it give you the mandate to treat a juvenile as an adult? The answer is a no, is an empirical no. Moreover, Sudha, you have to also consider that we are living in different times where these kids, these children are exposed to multiple, shall I say, screens, from a television to a mobile to internet.
Yeah.
And what is really happening is that these young children are leapfrogging from their teens into adulthood straight away.
Hold that thought. I'm a mom, and the only thing I tell my children is always stay on the right side of the law. I don't want that to happen. This I've said since they were 2 years old. I'm not saying I'm unusual.